Good morning, everyone. Welcome to the Fast Forward webinar series provided by Infinit-I Workforce Solutions. My name is Mark Rhea, and I'll be hosting our event today. We've got an extremely important topic to cover today. The new ruling that was made by the federal motor carriers on crash prevention determination. We've got an excellent guest speaker with us today, Mr. Mike McConnell, who I've worked with for many years at Frozen Food Express. He and I have worked through multiple crashes and crash prevention programs to include online training as well as compliance issues. He's also spent a large part of his career with the Cisco company down in Houston, Texas, and he's joining us today from the Alamo City, San Antonio, Texas. Mike, you want to introduce yourself and tell us, kind of set the theme for today?
Yeah, thank you, Mark. Thanks for that great introduction. So Mike McConnell, I started the trucking business back in the late 70s, started driving in early 80s, went to work for a truck driving school after that, and started my safety career full-time in 1990 at FFE, as Mark mentioned. So this program has been a pretty hot topic for the last 3 years or so with the ATA Regulations Committee and some other industry peers and executives. And, you know, we actually got a lot of cooperation with industry and FMCSA to make this happen with a lot of moving parts and a lot of people involved. So that's what we're going to talk about today, is the ability to challenge crashes as being preventable or non-preventable, DOT crashes I'm referring to, and the huge step that was taken to help the industry with that.
Yeah, you know, Mike, it's kind of humbling thinking back of the some of the decisions that have been made relative to driver terminations or not hiring a driver based on CSA points and not giving any ability to make a non-preventable determination. So, you know, this is a big step in the right direction. Just to kind of set the tone on how we got here, the CSA program rolled out 10 years ago in 2010. We were surprised at some of the initial results that rolled out, but we certainly supported the project as the best mousetrap around relative to making a safety fitness determination based on roadside inspections, based on crash data. But we have learned a few things over the 10 years. We have added electronic logs, which was a big help. But the program still has some shortcomings. I think we would all agree. One of the examples is the people and entities that are using some of the CSA data that really wasn't designed for. Examples for that would be insurance, shippers, you know, insurance companies making decisions on premiums or non-renewals, and shippers, I want to hire this carrier or that carrier based on a CSA. And of course, our friends in the plaintiff's attorneys world have learned that these numbers are available and have used them a number of times. So I've got that kind of sets the tone on where we've been. We've got a major breakthrough, and I've got a couple of polling questions, if we could pull those up for the audience. And while we're answering those, I've got a question. First question, experience, what does the CSA program need? First answer is tweaking. This is a move in the right direction. B, overhaul, scrap the whole program and start all over, or no change at all. And the second question, which of the following parties your CSA scores? Insurance industry, renewal time, shippers and brokers, plaintiffs' attorneys, none of the above, or all of the above. So if you take a few minutes and answer those questions. And while you're answering those questions, I have a question for Mike. And it's got to do with it. You were involved, heavily involved in this rulemaking. Do you, as an industry subject matter expert, feel like this is a move in the right direction? And how did we get here? What role did you play, and how did this get through some of the rulemaking entities?
Yeah, that's a great question, Mark. So, yes, to start it off and answer the first part of your question, yes, I think this is a huge step for industry and FMCSA teaming up together. I think we're seeing more and more of that than what we did a decade or decade and a half ago. So my part with this was really the committee. The regulations committee with ATA was very involved in this. This was brought up as a suggestion through that committee, put out to lobbyists that went over to the federal entities in Washington, D.C., presented it. And a lot of this was based on some of the research that was done on crashes that got questioned quite a bit to FMCSA. So it was kind of a long story, but the short end to the long story is this is definitely a step in the right direction. I think you'll see more cooperation between industry and the associations such as ATA, truckload carriers, different national associations, and the FMCSA working together.
Right. So you've been involved in this for a while, and this is significant. So I don't know. Can we show the results of the poll? Interesting. Only 6% say no change, and 26% say start all over again. So what that tells me is it is a good mousetrap. It is a good safety fitness determination. It just needs some tweaking, and looks like everybody's been hit by somebody using these numbers. So cleaning it up will also clean up the insurance shippers and the plaintiff's attorneys getting involved. So, well, great. That's an interesting result. So, if we could go to the next slide, just to set the tone, I've got an example. We can go to the next slide, please. Yeah, see this guy in the yellow shirt was driving this truck, and if you can see the top of his trailer, he's motoring down the road minding his own business, and a small single engine aircraft hits the top of his trailer. That circle is the tire of a landing gear of an aircraft that hit the top of his trailer. And the highway patrolman there in his left hand, as you can see, is writing up the report. And this would meet the criteria if the aircraft was towed. I think luckily nobody was hurt, of points being assigned to this gentleman driving down the road, which was totally a non-preventable accident. Very unusual. This is the first one of these I've ever seen. And this is just setting the tone for what we are wanting to be able to challenge in this crash determination project. So, Mike, have you ever been involved in an airplane truck crash?
Mark, I can't say that I have. That was the first when I had heard about this prior, but yeah, that's it definitely would fall under what we're going to cover in a little bit as an unusual event.
Right. Now, you and I have covered some unusual events. We could tell some stories about that, but we don't have time for that. So anyhow, this is the type of accident that the program is designed to be able to challenge. And Mike, I'm going to turn the presentation over to you, and let's get into the details of this determination program.
Great. Thank you again, Mark. Okay, so just a quick history. On July 27th of 2017, Federal Motor Carriers announced this demonstration program to be able to evaluate preventability in 8 different crash categories and allow the industry to challenge these through data cues, claiming that they're non-preventable. And again, there were just these 8 categories, and they were pretty standard stuff: sitting, hitting the rear, falling debris. We won't go into the whole list, but there were these 8 categories. And if your truck was involved in one of those, you were able to go into data queues, challenge it as a non-preventable, and get a data queue result. They also, along with that, allowed carriers to go retro that date back to June 1st of 2017. So any accident you had from June 1st up until that date, you were able to go in and do the challenge. On August 5th of last year, 2019, and this was based on experience, a lot of very good input, a lot of challenges through the program, FMCSA proposed the Crash Preventability Determination Program and streamlined that process and added some more categories. They also set up a web page, which they, the acronym CPDP, which stands for Crash Preventability Determination Program, now has its own website. We're going to look at that in just a second. But again, companies are able to go in and challenge this. And one thing Mark mentioned earlier about the points going away for the company and the driver, and that's the beauty of this program, they're also tying it to the PSP. So if a driver is involved and it's deemed non-preventable, it won't show up on that PSP report against the driver. So it'll help you make better hiring decisions. In the past, it's possible you've passed on a driver based on an accident DOT that he or she may have had no preventability at all. So that's the kind of nuts and bolts of it. Colin, if you could go to the next slide. So here is a list of what we're calling the 15 categories. If you read that, you'll see there's actually only 10, I believe. So what happened is they looked at certain crashes that kind of fell in place with each other and combined those. So the category of 15 went down to 10, but it still includes, and it's all inclusive of those type accidents to be able to challenge. But this is the final list, and any accident you have as a carrier that's a DOT recordable accident that falls with any of these categories, you can go in and make that challenge through data queues. And if you notice that very last bullet point, rare or unusual, there's probably not many accident scenarios Mark and I haven't seen in our career, but I got to tell you, airplane's one of them. So that definitely, and in my opinion, I'm going to err on the side of caution because I'm certain that plane had to be towed. So I'm going to go DOT on that one in my personal register with my company. Then I'm obviously going to keep a close eye on the portal to see, how that comes around. But again, I'm sure they probably had to winch the airplane up on a trailer and carry it out. So that would be a tow away. And
Mike, the classification that no pun intended strikes me is that animal strike, and the multiple animal strike accidents that we've worked over the years. And if I'm not mistaken, we had one that was actually classified with a fatality. So they claimed the animal fatality charged against us, and it took quite a while to get that reversed. Is that true?
That's true, Mark. I am impressed with your memory. I remember that well. It was, if I remember right, it was an elk that we struck, and the police officer, where it asked for fatality, just happened to, if he did it by mistake as a joke, who knows, he marked fatality because of the elk, and we got hit with a fatality accident. Now, we were able to get that changed, through committee. It was before this had come about, but we did get that removed. But to your point, yes, that's a true story.
Yeah, the other big one is, of course, under the influence. Getting hit by someone who is under the influence or impaired is fairly common out there. So this list encompasses a large number of crashes that can now be challenged and, if successfully held up, removed from your CSA scores.
Yeah, and again, the big step with the industry and FMCSA teaming up and working together on this. It just, I guess for a better choice of words, I have to say it warms my heart a little bit to be able to see these two groups that have been, pretty separated in the past, coming together more and more. And I think this is just the beginning.
Great.
Okay, so I think we can go to the next slide, Colin, if you would, please. Okay, so just a quick review here. This is, we talked about most of this. Rare or unusual crash was added, and you see some references to a couple of different accidents over there. Have any of you ever had a skydiver land on top of your truck? Well, doubtful, but that happened somewhere, and obviously being a fatality, that's going to be DOT recordable regardless if there was a tow away or injury. That's a given. So the SMS scores are not going to reflect the non-preventable. In other words, it won't be factored into your per million mile rate. And then the SMS website will reflect non-preventable, preventable, and undecided. So those are the three categories: not preventable, which will be done through a challenge; preventable; and undecided. Again, we spoke about the PSP report. As part of the program, this will not be included in a PSP report on a driver, or it will be shown as not preventable and won't count towards his violation side of that report. And then also police reports got to be submitted when you're challenging one of these crashes. So it's important that when something like this happens, is one, make sure you do everything you can on scene to have your driver get a police report. In a lot of cases, people don't want to do that, especially if they feel like they're at fault in the accident. So that's a good one to remember. Try to always get that police report. Okay, then once this final rule notice is published, and that should be happening any day now, any of these crashes that occurred on or after August 1st of 2019 can be submitted. So they've retroed this program back again as the final rule was put in place. And you can go back to August 1st and submit your challenge through data queues for any of these categories, 15 categories of the accidents. And then moving on, we're going to get just a screenshot, I believe, on the next slide.
Mike, I've got to ask you one quick question. Just if you could go back to that slide. I know we're going to get the screenshots. It's not hard. I've got to ask you about bullet item 3. It has a classification of undecided.
Yes.
Undecided. Can you shed any light on that?
Yeah, I can. This actually was part of the committee discussion with ATA. So undecided is going to fall in when you challenge one of these and it goes to FMCSA. If they cannot determine one way or the other, it's going to go in this undecided category. Now, if it fits one of the 15 we're talking about, it should be cut and dried, especially if you have that police report, which will help you tremendously. But the only way the points are going to be removed, our understanding, is on the preventables that are deemed non-preventable. Now, again, when this is proposed final in the rule, that wording could change, but our understanding is that the undecided will still have the points included.
And I would presume, and I know we're early into this, that the default is a preventable. The challenge would put it into a determination, but to enter an undecided, it would have to be challenged at some point.
Correct.
Wow,
Correct.
That's and I sure wish that would have been available in some of the depositions I've given to some of our plaintiffs' attorneys friends, because they don't understand that the term undecided. So, well, this is a significant breakthrough in our industry here, being able to make this determination. The PSP reports and again, this poor driver we showed that was driving down in an airplane would have been hit. So, and if that would have hit his PSP report, and now it would hit as a non-preventable, and he could explain what happened rather than just charging him with a preventable accident.
Yep. And boy, that driver's got a conversation piece for a lifetime, doesn't he?
He does. Yes, sir.
Okay. Yeah, great point, Mark. Thanks for pointing that out, and thanks for bringing that question up. Okay, Colin, if you could advance, then we'll get just a quick look. So this is what the landing page on that new CPDP website is going to look like. And if you've noticed the arrow to the left, I pointed to the FMCSA data queues. If you click on that link, it will take you to the next page, which is, this is actually where you sign in into your CSA website. Now, I couldn't go further on this because I'm not tied to a specific trucking company these days as a consultant, but if you've got if you're the administrator for your CSA program, you can log in and you can access the data queues from here, or you can still go through the FMCSA portal like we've done for forever, basically, and that's, I believe, our next page. Colin's going to show that. And just a quick screenshot, obviously, this is an old company I worked with, so we didn't put the name up there, but if you see over on the top left, you've got that small arrow pointing data queues. When you click, it will highlight that data queue. Then you click on that go button, and it's going to take you into the data queue page here. And from here, really self-explanatory. If you've never done a challenge, I would imagine most of you on the call probably have. But if you haven't, I've got a couple more screenshots ahead of this to give you an idea. But this is where you go to start your challenge. When you get to the next page, you're going to choose crash event because that's what you're challenging. And the next page will show us that you believe the crash could not be prevented. And then this is just one click there. On the next button, of course, will take you to the next page. Now, this is the nuts and bolts of it. This is where you've got to put good information in there to make sure they get the proper accident pulled up. And that's obviously the state, your US DOT number, the FMCSA crash report number, which will be printed on that report, and then the event date. Now, it's key here, I believe, to know that when you're looking in the portal, for example, if you pull a loss run history for your DOT recordables, it's going to ask you if you want event date or posting date. Always choose that event date because FMCSA rarely gets anything posted the same day it happened. So you've got two different choices there. Posting date, which is when they uploaded it to the website. Crash date is when you actually when it actually happened, and that's always the date you want to use. And then, of course, your vehicle, state, and plate number. And then on the next slide, but I'll tell you from here, I didn't have actual data to put in. If you could just go to the next slide, please, Colin. We'll go in here for a few comments, but the next page is where you're going to do the nuts and bolts of it. Again, we didn't have a live crash to put in there, and I couldn't, for a lot of privacy reasons, put a crash in there from a previous carrier. So we'll leave that there, but it's, again, very self-explanatory. You put in there the information they request, hit the submit button, and usually within a couple of days to a week, you're going to get an answer on this if it goes the way most other challenges are go. Now, there's a good chance they'll be flooded with these in the beginning, so the responses may be a little slower. But right now, for violations and what we've noticed, I've actually challenged 3 of these with a previous carrier that fell in that determination program, and we won all 3 of them. I had my answer within a week on all 3. So anyway, comments on this, that's kind of the nuts and bolts of it. I know we went through the screenshots pretty quick, but if you have any questions or trouble creating a challenge, my contact information will be up here, as well as Mark. You can contact me anytime. I'll walk you through it over the phone, free of charge, no problem at all. Or obviously, if you need my services, we can do that as well. So, Mark, you want to
Yeah,
kind of
Mike.
start there
Well,
on?
yeah, Mike. Thank you. Thank you for that overview. This is a certainly can be classified as a major breakthrough. But here's the big question. The big question is what's next? What's next? Do you think this will be a conclusion of the CSA reform, or do you anticipate? I know there's a lot of talk about the ability to evaluate a carrier's safety culture, which is a little subjective, a little not quite as data driven. What do you think? Is there a follow up to this, or is this a one and done project for the CSA program?
I don't believe it is at all, Mark. I think the challenge piece is probably as far as it'll go, other than possibly adding some other categories as we go along. But I think this really opens the door to other areas of CSA, because there have been a lot of, I guess we'd say, controversial comments as to, what the program does to a carrier, especially a small carrier that doesn't get very many inspections. One out of service inspection can just nail you to the cross. And we've seen that time after time. Now, one thing I will tell you, as a consultant or a manager with a company, dig into these. And when you're doing these insurance reviews with your insurance companies, they base everything on history. That's just the nature of that industry. Dig into these. And a classic example, a carrier I worked with a couple of weeks ago had some very high numbers. Again, small carrier, didn't get a lot of inspections. But when you dug into the data, or when I really digged into the data, they'd not had a violation since June of 2019. And he was still paying for a lot of sins of the past and paying some pretty extremely high insurance rates. So it's a negotiation. When you're sitting at the table with them, challenge that stuff when you can, and go in and dig into the data, and don't take it for just what's on the surface. I guess that's probably the best advice I can give, Mark.
Okay. Well, I'm sure a lot of our listening audience is scrambling around saying, okay, I need to figure out how to challenge some of my non-preventable accidents. But if the safety culture is the next step, and there's a lot of, I know the National Academy of Science did a large study on CSA, and this was one of their conclusions. What would you consider important for a carrier to prepare for a cultural assessment of their safety fitness?
You can never do enough training, Mark. That's whether it's just the culture, from a just from a loss prevention or litigation. You can't do it enough. And I've done expert witness stuff for attorneys and insurance companies, and that's one thing that anytime we don't do well in litigation, 90% of the time it's based on a lack of training, whether that's scheduled training annually, biannually, however you do it, or remedial training after an accident is huge. That's what the attorneys want to see. That's what it's easy for us to fight the plaintiff's attorney on, and include that in our reports. And Infinit-I is a great tool. I've worked with these guys for a number of years. Use the program. For the cost effectiveness, you can't beat it. And there's great programs out there. This is one that I'm proud to say that I have partnered with because I believe in it. It doesn't sink the ship for cost. You just can't beat it. But whatever you do, just make sure that training is done, and stick to your program. Don't vary off of it. You like this driver a little better than the other one, be consistent. That's another key.
Yeah. Another thing we have found out through multiple depositions, of course, is doing the training and then being able to document that training are two different two different issues. And I know there's a lot of new technology, there's cameras, there's a lot of things coming out there. So if the next step is a cultural assessment of a carrier, the actions taken to challenge a crash, the technology that's being utilized as a reasonable expectation, documented training, documented DQ files. All of these things are going to be boiled up into a cultural assessment, and I think that's probably next on the horizon for our for the CSA program, which I certainly agree with.
Yeah, I think you're right, and when you break all this stuff down, I think you'll see that you'll be surprised what you see if you haven't done that. And if you're good at doing like little graphs and trending graphs, that's great to do with that data from your CSA scores. You can see if your violations are going up and down, but that trend line means a lot. And insurance carriers like to see that too, is even if you have a bad inspection over, the last year or so, that trend line doesn't necessarily mean it's going to creep up. It could keep creeping down. And that's basically showing that, even though you've had a hiccup or two along the way, you're actually trending that trend is going down and not going up, which is big.
Recognizing and then doing something about it. So we've got a lot of questions, so I do want to keep rolling here. If you can go to the next slide, Colin. So looking ahead to preparing for a cultural assessment, Jay and his team at Infinit-I Workforce Solutions is now offering a 30-day free trial, which I would certainly take advantage of. Get yourself ready. Do you have the corrective actions documented for out-of-service violations, for anything that hits your CSA program? They have content that covers, I think, 850 different modules of content. So they're offering a 30-day free trial, which I strongly encourage. And Mike, you're offering a 20% discount for anybody that needs to your assistance in cleaning up some of their CSA scores, and looks like that information is there. I don't know if you want to discuss that a little more.
Well, yeah, and actually there's a link to Infinit-I on my website. So if you have the need or you want to look at my website, easy, www.tsmconsultingllc.com. You can access Infinit-I from there, or obviously, directly to the number there. But I would recommend everyone on the call, if you're not using it, take them up on that 30-day offer. I think you'll see the bang you're going to get for your buck out of these folks is huge. And this is not this isn't a sales pitch for Infinit-I. I believe in it. I'm passionate about it. And, and I think Mark would agree, and his passion for safety is as much as mine, if not more. That, when we believe in something in the past, we support it, we support it, and we push it out as much as we can. And it's a great program.
Colin, if you can go to the next screen there. Yes. And we've been at that deposition. We've been on that side of the, there's the contacts, and I think there's a poll question. Next slide. Here you go. Okay. If you want to learn more about the 30-day complimentary and preparing for the next stage, just hit yes. If you want to talk to Mike about his services and how you can help start the cleanup of your CSA scores, then hit yes there. We'll contact you here in a little bit on that issue. While you're answering that, there's a number of questions here that have popped up. If I can get this to work. Here's a question. Overwhelmed safety manager here. New to this role, is it worth my time to go through the resubmission process? I'm assuming they're talking about the challenge process. Mike, you want to jump on that one?
Absolutely. It sounds like that may be one they submitted and did not win. If that's the case, there are some steps you can take probably better if we take that on the side note. If they want to call me or email me directly, we can talk about that more. But if it's a challenge you haven't put forth, by all means. What one we don't want to do is they're very clear what areas on these accidents that we can challenge. Don't throw one out there that doesn't fit it, because that's one thing that, that takes stability and integrity away from the industry. If it fits that, by all means, put it out there. Or if it's a violation, by the same token, you don't feel like it's should have been written, based on what the facts are, challenge it. Another one is stacking violations. We see that a lot. I've challenged a lot of those where you got, say the trooper found 8 brakes out of service. He wrote up 8 violations instead of 1. We've been able to challenge, and that's huge. I mean, that was almost 200 points in one inspection. We got that knocked down to about 50 points with that one challenge. So yes, by all means, put them out there.
Here's another question. Why did they go back to August 1, 2019 and not further back to be able to challenge a non-preventable crash? It's a great question.
Yeah, and the answer to that is we don't know the answer to that, to be honest with you. I've done research on that through committee, and we didn't get to meet due to COVID-19. Our committee didn't get to do our last staff or committee meeting back in February when all this, or actually March, I stand corrected. So the question is, we don't really know why that didn't go back further. The good news is, I guess, to that is they are allowing us to go back for that 6th or 7th month period, whatever that is. So I will tell you this, I won't give up on that. If I do find an answer, I can certainly include it to this recording or shoot it out to the masses that were on here. If I do get a better answer, you have my word on that.
Okay. Here's another question. In the first phase of this program, even though the accident was deemed non-preventable by FMCSA, the accident remained on CSA with a disclaimer. Going forward under this phase, will the accident be removed or still remain as a non-determination is made?
It will remain, but it will show as a non-preventable, and it will not calculate into your per million mile rate. FMCSA has been very clear on that. So you have to remember that FMCSA compiles data for both sides of the fence, the trucking company and the four-wheeler, for a better choice of words. So they keep that data because they want to see a lot of things. They want to see, were drugs and alcohol involved? Was the car at fault or was the truck at fault? So they're not going to remove it completely from the portal or your account, but it will not go against your points, your per million mile rate.
Gotcha. Okay. Here's another one. I know we don't know the answer to this one, but it's such a great question. Will you be able to challenge an undecided decision?
That's a great question. My guess would be probably so. I think probably one of the only things, or not the only thing, but I think one of the things that would probably knock it to an undecided is, say, for example, you challenge one but did not have a police report, but you had really good facts from the accident. They look at it and say, okay, we specifically asked for a police report. Go get that and resubmit your challenge. There's nothing really written about that to this point, so it may be one of those we'll know the answer for sure the first time it happens. But my opinion would be, from working with rules like this for a long time and working more closely with FMCSA now with the regulations committee, that we will be able to. It's probably going to be due to something that was left out in the original challenge.
Gotcha. Okay, well, let's wrap everything up here. We've covered a lot of ground here. We polled the audience, and the 70 percentile of the group said that the CSA program just needs tweaking, which this is clearly a tweak, a significant tweak in the right direction. Everybody appears to have, someone has used their CSA scores to establish a premium for an insurance, or used against you in a lawsuit, or make a decision to use you or a competitor based on these scores. So managing these scores is that requirement's not going away, and we can anticipate more changes, and those changes will probably be toward this cultural. And when I say cultural, what I guess the best way is, do you practice what you preach? Are you putting on a show that you support safety, or are you actively practicing with the best technology, with online training, with documenting your training, all the cameras that are out there, all the things that could be assessed on a day-to-day carrier's world? Are they actually doing things? And I think that's a huge move in the right direction. So we're right on time here. Next week, we have a very exciting topic, fit for duty, which is very applicable in today's world. We'll have Dr. Shirley be joining us about a fit, who's done probably 15,000 fit for duty determinations and back to work requirements for office and administrative staff, and how do we get back to normalized work world, and this from the views of a doctor who is actually nationally renowned for the work he's done. So that'll be next Thursday. Mike from San Antonio, thank you very much for your input. It's a big breakthrough, and thank you for the work you did with the ATA and the FMCSA to get this rulemaking in place.
Great. Thank you, Mark. Really enjoyed this, and, look forward to these in the future.
Thank you very much. We'll see you next week.
Thank you.